Hello everyone, welcome to MAYANK LAWHOLIC. In this video, we will discuss case laws related MCQs of the constitutional law, questions related to emergency. Question number 1. Scope of Article 356 was examined in the case of A. S.R. Bommai vs. Union of India. Question number 2. In which one of the following cases did the Supreme Court observe that there is a need to confine the exercise of power under Article 356 Clause 1 strictly to the situation mentioned therein, which is a precedent to the said exercise? It was held in the case of S.R. Bommai vs. Union of India. Question number 3. S.R. Bommai vs. Union of India is related to President rule in the state under Article 356. Question number 4. The Supreme Court has laid down guidelines for imposing emergency under Article 356 in one of the following cases. The answer is S.R. Bommai vs. Union of India. Question number 5. The Supreme Court of India, while considering the validity of proclamation of emergency under Article 356, said that the proclamation is subject to judicial review in one of the following cases. That is in the case of S.R. Bommai vs. Union of India. Question number 6. In which case the dissolution of Bihar Legislative Assembly by the governors before formation of the government was declared unconstitutional? It was declared unconstitutional in the case of Rameshwar Prasad vs. Union of India. Question number 7. Now the fundamental right to life and liberty cannot be suspended even during emergency. It is made possible by 44th Constitutional Amendment Act. Question number 8. The Supreme Court of India, while considering the validity of proclamation of emergency under Article 356, that the proclamation is subjected to judicial review. Which one of the following case it was held? It was held in the case of S.R. Bommai vs. Union of India. Now we shall see the questions related to amendment, that is Article 368. In which of the following cases did the Supreme Court held that amendment of the Constitution under Article 368 was law within the meaning of Article 13 of the Constitution of India? It was held in the case of Golaknath vs. State of Punjab. In which one of the following cases was it held that a law made under Article 368 would be subject to Article 13 Clause 2 like any other law? It was held in the case of Golaknath vs. State of Punjab. Question number 3. In which case it was laid down that the amendment in the Constitution is exercise of legislative functions of the Parliament? It was held in the case of Golaknath vs. State of Punjab. 4. In which of the following cases did the Supreme Court hold that basic structure of the Constitution of India cannot be amended by the exercising the power of amendment under Article 368? It was held in the case of Keshwananda Bharati vs. State of Kerala. In which of the following case the Supreme Court has ruled by the majority that Parliament cannot amend fundamental rights exercising its power? It was held in the case of Golaknath vs. State of Punjab. Question number 6. In which of the following cases was it held that a law made under Article 368 would be subjected to Article 13 Clause 2 like any other law? It was held in the case of Golaknath vs. State of Punjab. Question number 7. Non-amendability of the basic structure of the Constitution was declared firstly in Keshwananda Bharati vs. State of Kerala 1973. Question number 8. Read assertion and reason given below and answer using the codes. Assertion: the power under Article 368 of the Constitution is a constituent power subject to the constitutional scheme as to distribution of legislative power according to the entries in the 7th schedule. Wrong. Reason: because Shashanka Shekhar Maiti vs. Union of India decided so. No, both the assertion and reason are wrong. Question number 9. In which of the following cases the Supreme Court of India had invalidated a constitutional amendment for non-compliance with the procedure contained in the proviso of Clause 2 of Article 368? It was held in Kyoto Holan vs. Zakilu and others. Question number 10. Which of the following case is not related to theory of basic structure under Article 368 of the Constitution? T.K. Rangarajan vs. Government of Tamil Nadu is not related with basic structure. Remaining Minerva Mills vs. Union of India, Vaman Rao vs. Union of India and L. Chandra Kumar vs. Union of India are the cases related to theory of basic structure. Which of the following statements is incorrect? A. Shankari Prasad vs. Union of India was overruled in Sajjan Singh versus State of Rajasthan. B. Shankari Prasad versus Union of India. It was held that the word law under Article 13 Clause 2 does not include a law made by the Parliament to amend the Constitution of India under Article 368 is the correct statement. C. In Golaknath versus State of Punjab, AIR 1967, it was held that the word law under Article 13 Clause 2 includes parliamentary law amending the Constitution. True. In Keshwananda Bharti versus State of Kerala 1973, Golaknath case was overruled. True. So the incorrect statement in the options given above are A. Shankari Prasad versus Union of India was overruled in Sajjan Singh versus State of Rajasthan. Question number 12. In which of the following cases the Supreme Court decided that a constitutional amendment which takes away or abridges a fundamental right would be void and therefore forced the Parliament to enact the 24th Amendment Act? It was held in the case of Golaknath versus State of Punjab. Question number 13. In which case the Supreme Court declared clauses 4 and 5 of Article 368 of Constitution as unconstitutional? In the case of Minerva Mills versus Union of India 1980. Match list 1 and list 2 and give the correct answer by using the codes given below. List 1. Keshwananda Bharti versus State of Kerala. Basic structure doctrine was created. Indira Nehru Gandhi versus Raj Narayan. Basic structure doctrine was strengthened. Minerva Mills versus Union of India. Basic structure doctrine was crystallized. I.R. Koilu versus State of Tamil Nadu. Basic structure doctrine. New dimensions were added. Question number 15. The fundamental rights can never be amended as it is beyond the purview of the Parliament. Such ruling was given in Golaknath versus State of Punjab. Now let us see a few questions related to freedom of trade and commerce. Question number 1. Automobiles Limited versus State of Rajasthan is a case related to freedom of trade, commerce and intercourse. Question number 2. Constitution Bench of the Supreme Court in Jindal Stainless Steel versus State of Haryana 2016 has explained the Constitution provision regarding restriction on trade and commerce. Question number 3. In which case the Constitution Bench of the Supreme Court gave detailed analysis of the compensatory tax? In the case of Jindal Stainless Steel versus State of Haryana. Question number 4. In Nazriya Motors versus State of Andhra Pradesh 1969, the court held that even if a bill which has received the assent of President under Article 304 Clause B, the court can examine the validity of such law on the grounds whether it is for reasonable and in the interest of public. In which case the Supreme Court observed that regulatory measures and compensatory taxes for the use of trading facilities did not hamper trade, commerce and intercourse. Was held in the case of Automobile Transport Limited versus State of Rajasthan in 1962. Now these are some miscellaneous cases related to Constitution. Question number 1. P.A. Sangma versus Pranab Mukherjee 2013 was case decided by Supreme Court by a majority of 3:2. Question number 2. The case of Bihar versus Kameshwar Singh is related with which of the following doctrines? With doctrine of colorable legislation. Question number 3. In which of the following cases the Supreme Court invalidated clause D of the Article 323A of the Constitution of India in L. Chandrakumar versus Union of India? Question number 4. In which one of the following cases did the Supreme Court rule that the power of judicial review vested in the High Court in respect of the decision given by the service tribunals cannot be ousted or excluded even by a constitutional amendment? This observation was made in the case of L. Chandrakumar versus Union of India. Question number 5. Responsibility of abuse or misuse of quota cannot be a ground to declare it unconstitutional. Need of quota is a matter of the policy of the government and it cannot be examined by the court. The Supreme Court of India so held in the case of People's Union for Civil Liberties versus Union of India. Question number 6. The Supreme Court held that election commissioners cannot be placed on par with the Chief Election Commissioner in terms of power and authority in the case of S.S. Dhanova versus Union of India. Question number 7. In which one of the following cases the Supreme Court held that no election can be challenged on the ground of defect in electoral rolls? It was held in the case of Indrajit Barua versus Election Commission of India. Question number 8. The Supreme Court of India said that it is not the duty of the court either to enlarge the scope of the legislation or the intention of the legislature when the language of the provision is plain and unambiguous in one of the following cases. In the case of A. Union of India versus Devaki Nandan Agarwal. Question number 11. Arrange the following Supreme Court decision on the justification of torts in the chronological order by using the quotes given below. In the options given below, the first case held was Anwar Hussain versus Ajay Kumar, Vinod Kumar Santilal Gosalia versus Gangadhar Narsingh Das was the second case held, Sodan Singh versus New Municipal Committee. Third, Nizam's Institute of Medical Sciences versus Prashant S. Dhananka was the fourth case. Question number 12. Nobody can be above the institution which he is supposed to be served. He is merely the creature of the institution. He can exist only if the institution exists. To protect the individual as mightier than the constitution would be a grave injustice. In which of the following cases the Supreme Court to Chief Justice Sikri has observed this? This observation was made in the case of T.N. Seshan versus Union of India by Justice Sikri. Question number 13. We have to evolve new principles and lay down new norms which will adequately deal with the new problems which arise in a highly industrialized society was laid down in the case of M.C. Mehta versus Union of India. Question number 14. In which of the following case the Supreme Court held that an intermediary shall be liable for a third party information hosted by him if upon receiving actual knowledge from the court order or on being notified by the appropriate government he fails to expeditiously remove that material. The statement was made in the case of Shreya Singhal versus Union of India related to Information Technology Act. So the correct answer to this question is Shreya Singhal versus Union of India. In which of the following judgments the Supreme Court explained the effect of 42nd Amendment on the protection available to civil servants under Article 311 of the Constitution of India 1950? A. Managing Director Electronic Corporation of India versus B. Karunakar. B. Union of India versus Tulsiram Patel. C. A.K. Karaipak versus Union of India. D. S.N. Mukherjee versus Union of India. The answer is Managing Director Electronic Corporation of India versus B. Karunakar. Question number 16. In Madras Bar Association versus Union of India, the Supreme Court declared the National Tax Tribunal Act 2005 as unconstitutional on the ground that A. The Act empowered the National Tax Tribunal to give decisions binding on central and state government. B. That it encroached upon the exclusive domain of the superior courts of the record and the principle of separation of powers. The Act failed to ensure the independence of the tribunal established under it. D. None of the above. The correct answer to this question is B. That it encroached upon the exclusive domain of the superior courts of record and the principle of separation of powers. Question number 17. In which of the following cases the Supreme Court struck down Section 66A of the IT Act 2000 in the case of Shreya Singhal versus Union of India? Question number 18. The constitutionality of the Haryana Panchayati Raj Amendment Act 2015 was challenged in the case of Rajbala versus State of Haryana. Point out the incorrect match. A. G.K. Krishnan versus State of Tamil Nadu, Freedom of Trade. Correct. K.C. Gajapati Narayan Deo versus State of Orissa, Residuary Powers. No. Zaveri Bhai versus State of Bombay, Repugnancy. Right. State of Bombay versus F.M. Balsara, Doctrine of Severability. Right. So the incorrect answer asked in this question is option B. K.C. Gajapati Narayan Deo versus State of Orissa. Question number 21. The decision of the Supreme Court in R.C. Paudyal versus Union of India deals with State of Sikkim. Which of the following cases does not relate to the civil servants? D. Samsher Singh versus State of Punjab does not deal with the civil servants, but the remaining cases Union of India versus Tulsiram Patel, J.P. Bansal versus State of Rajasthan, T. Rangarajan versus Government of Tamil Nadu deals with the provisions of Article 311 of the civil servants. Question number 25. The opinion of the Amicus Curiac in Aruna Ramachandra Shanbaug's case was A. In favour of passive euthanasia provided the decision to discontinue life support was taken by responsible medical practitioners. B. In favor of passive euthanasia, provided the decision to discontinue life support was taken under the provision of the higher judiciary. No. C. In favor of both passive and active euthanasia. No. In this case, active euthanasia was not dealt. Only the passive euthanasia was spoken about. In the favor of both passive and active euthanasia, provided the decision to discontinue life support was taken by responsible medical practitioner approved by the judiciary. No. D. None of the above. So the correct answer in this question is option A. That is, in the favor of passive euthanasia, provided the decision to discontinue life support was taken by the responsible medical practitioners and not by the supervision of higher judiciary. Question number 26. In which case it was held that the Supreme Court and High Courts can direct the CBI investigation without the consent of the state government? It was held in the case of State of West Bengal versus Committee for Protection of Democratic Rights, 2010. Question number 27. In which case the Supreme Court upheld the Haryana Panchayati Raj Act prescribing minimum educational qualification for contesting elections of panchayats in the case of Rajbala versus State of Haryana. Question number 28. In which case Supreme Court ruled that the defense of sovereign immunity is alien to the concept of guarantee of fundamental rights? It was held in the case of Nilabati Behra versus State of Orissa, 1993. Question number 29. The Supreme Court has directed the Law Commission of India to examine various issues relating to the working of tribunals, including the desirability of providing statutory appeals directly to the Supreme Courts from orders of tribunals on issues not affecting national or public interest, and other aspects of statutory frameworks in respect of tribunals. It was held in the case of Gujarat Urja Vikas Nigam Limited versus Essar Power Limited. Question number 30. Match list 1 with the list 2. The cases with the articles involved and select the correct answer using the codes given below. Essar Bommai versus Union of India is related to Article 356. PV Narasimha Rao versus State is related to Article 105. ADM Jabalpur versus Shivkant Shukla is related to Article 21, and Lily Thomas versus Union of India is related to Article 44. Next question. In which case Article 323A Clause 2 Subclause D and Article 323B Clause 3 Subclause D were declared unconstitutional to the extent they exclude the jurisdiction of the High Courts and Supreme Court under Article 226, 227 and 32 of the Constitution. This was held in the case of L. Chandra Kumar versus Union of India, 1997. Question number 36. The constitutional validity of Bhopal Gas Leak Disaster Registration and Processing of Claims Act 1985 was challenged in the case of Charan Lal Sahu versus Union of India. Question number 37. In which one of the following cases preamble was held to be the part of the Constitution, hence amendable? It was held in the case of Keshwananda Bharati versus State of Kerala. Question number 38. In which of the following cases the Supreme Court has held that the laws in the 9th schedule are also subject to judicial review? It was held in the case of I.R. Koilu versus State of Tamil Nadu. Question number 39. Blindness is not a disqualification to become a member of UPSC, in which case it has been declared. It is declared in the case of Jaishankar Prasad versus State of Bihar. With this we come to the end of constitutional law case laws related MCQs videos. All the videos are uploaded and you can find the videos in the playlist given in the I button. Thank you for watching the entire video and giving your appreciation. We hope these videos help you in your preparation and make your revision much better and easier. So if you like these videos, please like, share and subscribe to our channel Mayank Lawholic, and share these videos with your friends who are preparing for judiciary and encourage them in their preparation. Thank you for watching.